from Springfield, Illinois, and to part 2 our webinar dealing with rental property management and real estate brokerage. This is Steve Bohenik and Betsy Urbance, and happy to be with you this morning. We had such a wonderful response to our last webinar. It was overflow crowd, and I want to say, unfortunately, this morning it looks, fortunately or unfortunately, fortunately for those who are participating, unfortunately for those who want to participate, we've reached our max again today.
We'll have to watch the recorded version.
You'll have to watch the recorded version.
Tell your friends.
It'll come up on the website, hopefully sometime Friday, and we'll
maybe sooner, but later.
And as we always say, it's always asked, and we always say, you cannot just download the PowerPoints that you'll see today. They have to be watched in conjunction with the tape, the audio of the presentation, because they really, without the audio, they could, nobody could misunderstand them. So we want to make sure that they go together.
You have an audio-only option. You audio only. You can do audio only, or you can do them combined, but not slides alone.
Very good. And so what we're going to do today, and if we look at the first page here, we'll do an overview. And we're going to, a couple of points here that we're talking about. There were several questions that came up last time after the program about adverse action under the Fair Credit Reporting Act. And so we're going to talk about that a little bit. The Illinois Security Deposit Return Act, there's been some, and then we'll talk about that, because that was really something we didn't touch upon last time. And then questions, and I will say we've received a number of questions in advance, and those questions we've received in advance are ones that we will see some of those on the PowerPoint. After we're done with the PowerPoint, we've got more. We didn't have a chance to get on the PowerPoint because of the timing, and we'll deal with those as time allows. And questions came in. I think our last question we received was maybe 5 minutes before the presentation here. So we'll try to get through those, and then we'll try to deal with those that we see come in online here during the course of the presentation. If one fits within an area, we'll handle that there. But without further ado, so we can try to get through as much as we can here this morning, we're going to offer the clarification on the Fair Credit Reporting Act, and I'm going to ask Betsy to take it from here.
Why, thank you, Steve. I feel like throwing it over, right, in the news world.
See if you can catch it.
Right. It's a close question here this morning. But clarification, we talked in a prior webinar about adverse action and need for a landlord or a property manager to give notice if you had used the services of a third-party credit reporting agency, and based on information that you received back from that CRA, you can see that's the acronym we're going to use, you either denied their application for rental or you changed the terms from those that would be the most favorable. So you've required a higher amount of rent or a higher security deposit. And clearly, under the Fair Credit Reporting Act, and that's mostly, that's where we're taking our information here today, which is federal legislation and rulemaking. You have to provide an adverse action notice, and in that prior webinar, we gave you some of the contents of notice. Would you have to then provide adverse action notice if you got information or negative information from a private landlord? I think our indication to you last time was you probably would not have to provide that notice. Probably better practice that you would provide that notice. After review of the Fair Credit Reporting Act, depending on who my client was, I could probably make an argument either way. But better practice would be to go ahead and give an adverse action notice. And you do have to tell a person if they ask you, then within 60 days have to give them your source of information so they can find out what kind of information that negative. I use as an example the negative report for landlord.
And I think that we'll try you try to find a term, negative or whatever.
Right.
But there's information that you learn. Some may not consider it negative, but if there's information that you learn that would lead you to give a negative response to the request to rent, that's really what we're talking about.
Right, exactly.
Yep.
Exactly. It's mud, right? So the form of the adverse action notice, we did talk about it a little bit in a prior webinar, but we'll hit the items again. If a prospective tenant is denied or the terms differ based on the information you received, if you use a credit score, there were some recent amendments that went into effect in July 2011 under the Dodd-Frank Act, that if you used a credit score, to include that credit score in your adverse action notice. Tell them if there wasn't enough information supplied to you from the credit reporting agency. Some have no credit history. Cash people might be tenants, but they have no credit history, so you'd have to tell them that if there's nothing available on them. Or if you received information from other than a credit reporting agency, so you'd want that checkbox in your notice. When you do use a credit reporting agency and the credit score, you got to give the score itself, as I told you before. You need the name of the credit reporting agency. I think everybody's kind of familiar with the big three: TransUnion, Experian, and the other ones escape me. You're all saying it along with me. The tenant may obtain a copy of the report. They might dispute the accuracy of the report, so they need contact information to that credit reporting agency so that if they wish to discuss the dispute or to put something on file, that give reasoning behind what's happened on the report or what shows up. I want a statement there that says that the CRA did not make the final decision. They provided you the information. And also now under amendments, need to include factors that adversely affected the credit score. And those
would probably come from CRA itself.
Right. They would come from the CRA, and they'd be part of their report. Question. Does this apply to both residential and commercial? I would have to look at that. For sure residential, and yes, probably commercial. I looked at it more with an eye towards residential, and there is.
Well, yeah, it certainly applies to residential. I'll tell you what we'll do. We will double check on the commercial aspects, because sometimes these don't apply to commercial, but we will double check that, and we will post information that would indicate whether that applies in the commercial context.
Don't check that. We did input from one of our members that was online last time that is an example where a broker was running credit reports and then supplying other brokers with those credit reports. Here's a concern here. Have you then become a credit reporting agency and put yourself under the auspices of the Fair Credit Reporting Act with regard to activities? We didn't want to turn this webinar into a Fair Credit Reporting Act webinar.
Beyond the scope of that discussion would be.
And as you will see, as this hour progresses, we had many other questions on many other rental-related subjects that we wanted to hit as well. But we would advise folks that may be in this situation, they want to talk to their attorney before they pursue this sort of practice, because they may be right in the Fair Credit Reporting Act and that would have to meet requirements. Switch gears.
Next up, Security Deposit Return Act. We really didn't touch this last month, so we wanted to touch on it here today. The particular act, again, as the name of the act implies, it's not the one that deals with the interest. It deals with the return of your security deposit. Those who lease buildings or a complex containing 5 or more units. So you got 5 or more units is the limit. So if you've got a single family, it's not going to apply unless complex that 5 or more, which would probably not be the case unless it's some kind of an apartment complex. The really deals with on the return, you cannot withhold any portion of that security deposit unless in a period of 30 days of the tenant vacating, the landlord provides in person or by mail an itemized list of the damages. I want to emphasize here that the law currently says in person or by mail that must be provided. And I say that because, number one, there was a case on an instant ordinance, I believe. There was an effort to email the itemized list of damages, and the court said, well, that's not sufficient under the statute because it's not in person or by mail under that particular ordinance, not under the state statute. Also, there is legislation pending in Springfield this year that would allow for the itemization to be provided by email. So clearly there's a concern that cannot be done that way. So you provide your itemization, the landlord does within 30 days after the tenant vacating. You have to include a cost or estimate of the repairs that would have to be made or that you're making. If you're actually made the repairs, you provide those receipts. If estimates are used, you have to provide actual receipts within 30 days from the date of the statement containing the estimates. You can include, under the state law, the cost of your own labor to repair items with respect to the unit. If no statements provided to the tenant, you must return that security deposit within 45 days. If it's a security deposit on which there needs to be interest, that would need to be paid as well. So 45 days after vacation of the premises, this would have to be paid over. If the landlord does not comply with the provisions of this act, the landlord is potentially responsible for twice the amount of the security deposit, court costs, and attorney's fees. So, for example, if you mailed under the current statute the itemization as opposed to giving it in person or by mail, then the landlord potentially is responsible for twice the security deposit, the court costs, and attorney's fees, even though those items actually had to be repaired because you didn't provide the proper notice. Another provision we would talk about is if there's a transfer of the property. Let's say you've got rental property, the tenant, the owner sells that property, someone else becomes the landlord at that point in time. The owner of the property, the new owner of the property, is also liable to the tenant for the return of the security deposit. But it's a joint and several liability between the old owner and the new owner, or the old landlord and the new landlord here. And there's also a new section we wanted to mention, section 1.2, that talks about property that has been foreclosed upon. If the transferee receives that security deposit and any accrued interest, the transferee has to post notice on the primary entrance of each dwelling unit, indicating that they have the tenant's security deposit. So the tenant knows where that security deposit is. Well, as I've mentioned that Evanston case before, there are a number of local ordinances out there that deal with security deposits, and you need to check your local ordinances to see what they say with regards to these requirements and the time frames, what you can do, what you can't do in regards to the security deposit.
We did get a question related to that. Is this applicable to individual condo lessor in a building of 5 or more units? And state security deposit return act, yes, it's 5 or more.
5 or more.
They've got to check local ordinances.
Yes.
That could be stricter.
Yeah.
So I don't know if you addressed that earlier, maybe not, but that question did come in.
Okay.
Before we move on, too, we had that credit application question. Do you want to do that now or later?
Okay.
That's the one that was on.
Trying to.
Marital status question.
Hey.
Yeah. There was another question that came in, and because it was related to credit application, we want to touch on that real quick. The question, is it a violation of protected classes to request credit information that includes marital status, as long as it includes civil union along with the married, single, divorced, etc., and clearly state it's part of the credit verification for renting. I guess we would say if this question is a question on an application, as credit is concerned, you want to know is who's going to be responsible for paying and who's responsible for paying the rent. So know that the status, the marital status, is going to be so important or relevant there. But ask those questions on an application because it's protected class. They should be optional. And so you can show that you're providing just to all and help you in your record keeping there. Whether or not it rented and it's credit information, you want to know who's going to be responsible to pay. Are there co-signers on the lease?
It's fair to request that information,
right.
I think.
So you want to request that information. If you are keeping track of any other stats that might be protected, you need to ensure it's on every application, and probably it needs to be an optional question. So there's that question, and is there any? So I got a question while you were speaking, Steve. Are you referring to managing brokers supplying the information or agents now licensed as brokers?
Well, I think you're referring to the landlord providing that information. And the question is, who's the owner? Who's the that has that security deposit? And even if the property manager or the managing broker has it, then it's still the landlord who is saying, okay, we want to return it, or we're not going to return it because there's repairs to be made. The property manager may give it as the agent, but ultimately it's the landlord's responsibility under statute to provide that notice.
Landlord's responsibility, and there may be a provision in your management agreement that sort of dictates that responsibility to you. And then background checks. I know the background checks. I don't understand.
Well, maybe unless we need to go on, I don't.
Yeah.
Let's go on.
Yeah, maybe
make sure we get through everything.
Said background checks. Clarify that question, please. Okay. Moving on to the questions that we received well in advance of the webinar. First one. The member asks, how can we add information on the lease about the first month rent being used to pay listing brokers' commission? The parties to the lease are the landlord and the tenant. You've got to remember that, and the broker is not a party to the lease. So the landlord should consult his attorney if he wants any language to be added to the lease. If the agent or the broker adds language to the lease, they're writing provisions into a contract to which you're not a party, and you've got problems practicing law without a license. Now, there would be a separate agreement between the landlord and the brokerage company and tenant, where there's some agreement. Tenant's paying first month's rent. Tenant's still going to get credit for that rent, but the amount's going to be paid to the brokerage company to cover commissions. Now, what you need to be careful of is making sure that separate agreement doesn't conflict in any way with what he says. So you don't want conflict there between those agreements. So we have had a related request, can create a form of agreement for three parties, if you will, for the landlord, the tenant, and the brokerage company. And for these reasons, it's very hard to create a form of agreement because we don't know the underlying lease language. There's our problem with creating a form, but let's say that forms could not be created in an area that dovetail or fit with a lease form that might be being used in the area. question we received, now the landlord wants to use his own form of lease, is the broker protected? Well, the broker in his listing agreement or in his property management agreement would want to have some hold harmless language and indemnification language that would maybe take some of that responsibility away if the landlord's using his own lease. If you're on the other side of the coin or the other side of the transaction, you're representing a tenant and the landlord's using his own lease, you advise your tenant to have his attorney review it before it signs that landlord provided lease. Say it again, said it on the last slide, saying it again. Add provisions to the lease yourself, not to it. Like tenant or parties to the lease, if you're drafting provisions, you are practicing law on behalf of someone else without the requisite license.
Just want to go back one time, and we can check further, but on the question that came in earlier about the application of the CRA to commercial transactions, the FTC, prior to turning this over to the agency, the position of the FTC staff appears to be that the FTC only applies to consumer reports, consumer transactions, not to commercial transactions. The one exception appears to be to that on an FTC report. It may be for a commercial transaction, but if you're seeking personal information about an individual, as opposed to their credit information about their business, you're seeking credit information about them individually, then it becomes a consumer report and be subject to CRA, even though it's in connection with a consumer or commercial transaction.
Dr. Ralph, did he do that research?
No.
Way to go. Or no, he provided the iPad.
That's right.
All right.
That's
We've got all kinds of technology in this room. You ask, we
next question, excuse me, I diverted there from the text. But next question that came in is, what's the best way to avoid legalities and extra work associated with handling security deposits? Could be called a one-time non-refundable fee. The cease or anything at all, but don't handle the security deposits. If you're the property manager, make sure that they go to the owner, and there's a provision in the lease agreement that provides for that in bold print.
License law says if there's a property manager and you're not going to handle the security deposit, there must be a provision in the lease waiving that in bold print.
So that you as a brokerage company may have a policy not to handle security deposits. So make sure that language is in the lease that way, or got a form that says that it's not going to be handled, and that both parties sign off on it, that the security deposit is going to go to the landlord. That is the easiest way to avoid those guys, and then the owner becomes the primary party on that. Could they call it a one-time non-refundable fee? The answer is they can, but they have to be a one-time non-refundable fee. You call it what you want, but you look at the facts of what's going on. It is called a one-time non-refundable fee. It better be a non-refundable fee. For example, you charge an extra fee, or the landlord might charge an extra fee for a pet to be in the premises, or a smoker is the premises. That is just examples. And there are, but they would be fees, and they wouldn't be refundable. If you have a fee that's refundable, even if it's not refundable, but it becomes refundable, I think you've got a problem, because now it's being held for the benefit of both parties and still going to be looked at as a security deposit. And the other comment that you're going to get sick of hearing here, but you need to check if there's any local ordinance that applies in your area, and you will, later in the presentation, we'll give you an example of why that is so important.
Right. And last webinar, you heard us say, what is the lease say? That always applies. And then what is, check the local ordinance. Those are our broken record items for you. Always check those.
Next, if a property management company owner has units available for rent and grant another company non-exclusive permission to advertise units and seek tenants for them, must this be in writing? Under the license law is yes, you need written authorization under the license law from the owner to advertise those properties for rent, for sale, whatever the case may be. Must be, now, whether in writing, maybe an email, maybe, but it's got to be in writing, and you better put it in your file so you have a record of that you have that written authorization. Make sure that what written authorization is, what your office policy, does that accept that kind of written authorization? So, but make sure it is in writing. The thing I'd say is, whatever your advertising may be in a situation like this, make sure it is truthful, not misleading. For example, let's say the manager has a model unit, for example, and this isn't the actual unit that's going to be. If you're going to be sure of that in your advertising, you may want to indicate that model and not the actual unit. But you, at least be careful not to represent that as the actual unit, or that the conditions or the amendments may change based upon the actual unit that is rented. But you need to make sure that your advertising is truthful and not misleading.
And one thing I would add just to this, the actual member that we were talking to on this very question, you had a property management company that had the exclusive agreement or brokerage agreement, so they're exclusively represented by another company. Mm-hmm. And this guy is like a tenant finding service, so he's another brokerage company, so the exclusive broker, and then you're the non-exclusive guy that has permission to advertise the units from the broker. You've got permission in this case from the broker and the owner. Mm-hmm. And under license law, you'd have to indicate if it's exclusively somebody else, so you might even have to include the property manager's name in there somewhere to avoid some claim that if you're advertising a specific unit. Mm-hmm. A thought for you. If you're not advertising a specific unit, but you say units available in this general area, we're looking for tenants, mm-hmm. No worries. Yeah. But
if you're advertising
a specific unit that's exclusively represented by another company.
And in that last example, Betsy, you may not even need written authorization at that point.
Right, because you've got authority from the listing management.
Or just advertising your services at that point.
Right, right.
That will help you find properties in this area for rent, as opposed to having any specific.
And that's the portion of the example that I gave, where you're non-exclusive, you're not advertising the specific units, you're just looking for tenants.
That's what I said.
Yeah, that's just to clarify. Okay, here we go. So this is kind of a follow-up question, but we got this one too. Must all brokerage agreements be in writing to be enforceable? And this was really a commission dispute question, came in as a commission dispute question, and the actual facts are those that a broker would have to pursue on his own on the advice of his own counsel. But the general question, brokerage agreements have to be in writing. No, we always say, I hesitate to say always, but lawyers like to say, get in writing. And an agreement must be in writing in order to be exclusive. So if you want to be the exclusive broker involved, it does have to be in writing. It also does give you the best opportunity to enforce it and to go take it into court and say, these are the terms of our agreement. Therefore, with our commission. If you have an oral agreement, obviously, no signatures, no written language to rely on other than the terms of the oral agreement. How do you prove those terms? Well, you either settle up or you go to the court, and the court will help determine what the terms are of that oral agreement. If there's none at all, there's an equitable theory of recovery. It's called quantum meruit. Thank goodness I took some Latin. so it really means what it's worth. That's a loose interpretation. But it's an equitable theory that you should recover because you provide valuable services that the customer, the client accepted, and you should be entitled to compensation. Theory, you get to argue unless there isn't a written or oral agreement.
Right. You not recover under Merrill if you're alleging that there's an oral agreement.
Right.
The argument has to be there wasn't an agreement, but this person accepted my service.
Accepted the services and the benefits.
The benefit, right.
Yeah. Another question, is it permissible for the property manager to contact the tenant applicant during processing of the application if the applicant has his or her own agent? Not an agent, go through the agent. You're just asking for trouble if you don't. You know, I wouldn't even get to whether the agency is exclusive or non-exclusive. If the tenant has an agent, go through the tenant's agent. And to have specific direction from the tenant's agent to do otherwise, do get consent to go directly to the tenant. You'd want to give that tenant a notice of no agency so they're aware that you represent the landlord side and you're not the agent for the tenant.
And primarily, this example is in where you're dealing with a prospective tenant.
Yeah, you're in the application process. Sure.
Okay. Interesting question here. A broker has a duplex listed for sale, and the unit is rented. And the buyer prospect wants to see a copy of the lease, the existing tenant's application to rent, and the report of that existing tenant. Can the broker provide that information to the buyer prospect? I think the broker can provide a copy of the lease. That's to the prospective buyer. That's an agreement that buyer is going to be assuming, and it is, I think it'd be for the due diligence of the buyer and fair disclose that and necessary disclosure by a prospective seller or by the seller to a prospective buyer. For, or the credit report are different than the lease. That information that was obtained by the original landlord or property manager when that lease was entered into. Decisions were made based upon that application and that credit report at that point in time, obviously, that resulted in the lease. Decisions were made by the owner, and so the lease is in place at this point. I have to release that information. The current owner of the property or property manager would need the consent of the existing tenant. Release that information, that credit report. The tenant that was probably on the application initially was the permission of the tenant to seek that information for purposes of rental. There was permission by the tenant on the time when they signed the application to release information to further individuals. So I think the current owner / property manager would need to go back and get that approval at this point in time to release that information.
Here's your example you alluded to before, Steve, about local ordinance. I got to remember to drive the bus here too.
Okay.
There it is.
Now, as I've mentioned to you previously, that's and you just mentioned here, we keep mentioning about checking the local ordinances. Now, why does this become so important? Number one, you want to comply with the law in the area. But, for example, recently, and this was picked up through a website of the IDFPR, Illinois Department of Financial and Professional Regulation, and reported an agent and a licensee under the Real Estate License Act was disciplined for rejecting a tenant prospect based on tenant's participation in the Section 8 housing voucher program. Now, the property was located in Chicago. The address on the DPR report shows that the agent what licensee had a Rockford area address. It's clear whether that Rockford area licensee was a Rockford area licensee at the time this transaction was entered into, or just moved to Rockford later. But lesson is learned from this, that the law on Section 8 voucher programs, but they're in Chicago, that says you cannot discriminate based upon the source of income being Section 8. So when a licensee on a rental in this a unit located in the Chicago area, it's based upon the source of income being Section 8, that violation of that ordinance in Chicago. Now, that's not the state law, and you may be from someplace else, that's subject to having a finding against you based upon your violation of that Chicago ordinance. The Real Estate License Act in Illinois says that if there is a finding of discrimination against licensee in any other jurisdiction, Chicago being a jurisdiction here, that the FPR must suspend or revoke your license. Must suspend or revoke your license. So the licensee in this particular case had a license suspended for a period of 30 days, violating that Chicago ordinance dealing with discrimination based upon Section 8 housing, a voucher program. That like I say, that doesn't, it's not just if you licensee in Chicago, and with the jurisdictions blurring, with LSs covering larger areas, you may be trying to do business, and understandably so, in jurisdictions other than where you're most familiar. But if you do that, you need to know what ordinances you're working under in this area, because, and this is not just landlord-tenant ordinance here, this is a fair housing or discrimination type ordinance. And so you need to know what those ordinances are, because a violation of that ordinance, even though you may not be familiar with it, is going to result in the suspension or revocation of your real estate brokerage license. If you're going to do business in an area, know what the local ordinances are. And in this particular webinar, either landlord-tenant ordinance or a fair housing or discrimination type of ordinance.
Right. There was a clarification question on our page 15, which was, can you provide the lease, the tenant's application, the credit report? I'm not sure the question answer understood. Let me clarify that Steve said that you could provide a copy of the lease, but you could not provide the application or the credit report with consent of the tenant, and the tenant not consent. So,
but if it consents,
if the tenant consents,
then you can provide the credit report. Yeah. So up front, application says, for example, that the landlord has the right to provide application and any credit to apply for a credit report, and provide the application and any credit reports to any prospective owners of the property. Now you've got consent, but you need that consent, not on the lease, but on the application and credit report.
I wanted to clarify because I'm not sure of that. Based on the question, there was some misunderstanding. As a leasing agent, may I share the credit report of a prospective tenant when recommending that the tenant to the owner?
What is it?
Well, if you're making the decision, I think you'd have to.
And I think your application would provide for that. In terms of what the prospective tenant's given permission for, but it should. I'll put it that way. It specifically should provide that.
Right.
But yeah, the owners making that decision, you're just acting as their agent. You're standing in their stead at that point in time.
Right.
It's better to have some kind of written coverage on that. That's for sure. But you're acting on behalf of the principal in this situation.
Right. a Section 8 related question, not exactly about the facts, but it says, what about when the rent amount requested is higher than the, I'm going to insert Section 8, voucher will pay? Sometimes there's a deficit in the rental amount.
I'm not sure what the question is exactly.
I'm not either, but if Section 8 is protected,
You still can't reject somebody simply because
based on that.
if they could, if that they can't cover the rent because Section 8 will cover the prospective rent and make up the difference, that may be a little different story because they can't make up the difference. But if they give you Section 8 and they can make up the difference, I think then, again, you're back to the source of income.
You couldn't, if you're in a situation where where source of income is protected, you can out of hand say, no, you get Section 8, you're out.
Right, and as we said, Section 8 is not protected on a statewide basis, but it is in some local jurisdictions.
Right. This is not so much a question, but a member after the last webinar shared a website that she's been having some success with where there's third-party tenant screening services provided, and it's run TransUnion, so that should give it a little credibility because it's one of the major credit reporting agencies, one of the national ones. So give you that link there in case you're interested in checking that out. Just kind of hint, not from Heloise. Now we're going off the grid a little bit into the questions that we received that weren't in time to make it to the PowerPoint. Steve has drawn the first one.
I got number one.
You got number one.
Okay, the first question that came in that was not able to be on here is, what happens to a tenant's furniture once they are evicted? What do you do with the stuff they leave behind? And I think I would say evicted, or if the tenant just leaves at some point in time.
Right.
Couple pieces of advice here. Number one is the best solution is have something in your lease that says what happens to tangible personal property left behind by a tenant. So the lease then controls, and it says whatever language is, if they've left it behind for a week or 30 days, whatever the language of your lease says, now you've got written direction that says what's happened to that tangible personal property. That's number one. The second option is that there is a legal action called distress for rent that a landlord can pursue to use tangible to allow the landlord to sell tangible personal property to use the proceeds of that to pay past due rent. So a legal option that's available to a landlord. And the thing I would say is then, again, as we've said, you need to look to see if there's any local ordinance that applies in any situation. There are any number of times, I'm sure, when a tenant moves out or has been evicted and doesn't take everything with them. And the landlord's question is, what do I do with this stuff?
Mm-hmm.
And there's no direction. Maybe there's nothing in the lease. They really don't want to pursue a distress for rent. They just want the back so it can be released. Now, what do I do with this property? Well, the thing I would suggest you do, because now you're in a bit of a self-help situation, is get a pictures or get a video of what's there. So you don't situation of a tenant coming back later on saying, oh, flat screen TV that I
flat screen TV.
Yeah, that I left
right before the Final Four.
Yeah. Now, so you want to have some documentation of what was there. So if there's an issue, you can say, okay, this is what was there, not anything else. And so number two, I'd suggest that you try to give some notice to the former to say, on whatever address or best address you have or email, whatever, the best way of contacting them possible, to say, listen, this we intend. We're going to hold this, or we're going to put it in storage or whatever for a certain period of time, and if we don't hear from you from that point, by that point in time, we're just going to give it to whatever charity or
It might be on that show where they sell stuff out of the storage unit.
Yeah. So tell them the best you can what you're going to do if you don't hear from them, but try to give notice to, and then document everything that was done, or if you sold it, what was sold for, so that if there's any question that comes back, you have documentation for that. But that gets difficult when you get into self-help. That's why it's best to have a lease provision.
Right. Also going to just a helpful hint from a member came in as a policy for these folks when they're doing property management activities. They tell the landlord that that it's up to the landlord to make the credit decision. So then the landlord doesn't come back on them later when the tenant goes out. And I'm quoting that directly. I had another comment related to this slide, or it wasn't a slide, the question. When, when an agent sells income property in his area, there's no forms used that authorize assignment of security deposit. I guess it wasn't what I thought it was. How do you unilaterally assign the tenant's money? There's no form that authorizes assignment of security deposit. If it's a security deposit, escrow rules will apply if you're holding it.
There's a couple of different scenarios here. I mean, one is the money being held by the licensee as a security deposit in escrow, or the actual security deposit being held by the owner of the property? Now, if it's being held by the broker, the sponsoring brokerage company, the property manager in escrow, you're going to be subject to those escrow rules.
Right.
And there's going to be written documentation for what's done with regards to those. And that means that, for example, there may be provisions concerning the assignment of security deposits to them from the current owner to the new owner. That doesn't mean that they'll move out of the escrow account,
right,
but it might mean that ultimately who the owner is, who might receive the security deposit, depending upon what happens to it after the transfer. But you need some documentation. But if an escrow in brokerage account, subject to the license law rules, follow the license law rules.
Right. So you might have to have, if you don't have joint written direction, you might have to have a court order, or you might have to go seek a court order. Another question that came in post creation was this one. It says brokerage company has a management agreement in place with a single condo owner, but they're managing that condo and they're renting it out for the owner of the condo. And the question came in, may hold the security deposit in an escrow account under their name for the condo owner. If they're a third-party manager, they must hold that security deposit in escrow. So that kind of dovetails with the last question, conveniently. It's got to be held in escrow, subject to the escrow rules, and yes, you would absolutely have to hold it in escrow account.
Okay.
Up, Steve. I was going to switch slides, but I don't have any.
Okay, the third question that came that we have up now after the fact was, does real estate licensee need a separate license for property management of condo, townhome, and single-family associations, or does the certification such as CMCA suffice? The new law in place that says that if you are going to be a manager of an association, and there's two kinds of management here. One is property. What does your real estate brokerage license entitle you to do? That means act as an agent for the buying and selling, or to lease properties. That your property management agreement gives you that authority. But are managing an association, condo, townhome, single-family, subdivision, whatever, common interest community association, where you're involved in what the meetings of the association, handling the money of the association, the fees that are paid to the association, insurance, and getting a fee for doing this association management. There's a law that says you're going to need a license. I think it's 25 units.
Right.
And it's a year after the regulations went into effect. So beginning October of 2012, you will need an association manager license to actually manage those associations, not provide real estate brokerage services, but to manage the association. Now, the CMCA designation, that type of thing, certification, might allow you not to have to take the education. I'm not sure if it'll grandfather you into that license, but you have to check that statute itself, because that's an association management statute. And that becomes effective for licensing October of 2012. There's legislation going through this year about payment of fees by the units, like a couple bucks per unit, to the department to help fund this new agency for a association management license.
Right. So it's administered by IDFPR, and they'll call it a CAM license. CAM. So if you're calling with questions, if you're calling IDFPR with questions about that, you can refer to CAM license. Okay. Next question was kind of a long one. I'm going to try and paraphrase, but it's a realtor who owned a townhouse, which she owns with her husband, and now this townhouse. We're quite clear on the facts because there's reference to a condo association, but there's also reference to a subdivision. And then there seem to be some requirements that if you're going to rent the unit, you have to submit a request to the governing association. This 60 days prior, if you're going to re-rent it. 2 days prior, you've got a request from the association, I suppose, permission to re-rent. We're fined by an association for not submitting that notice timely, and sort of the question is, can they do that? And we have a direct answer to that question. We don't, because we don't have the documents that govern whatever the association is that sets the rules where this property is located. But the analysis, generally speaking, number one, is there a common interest community of some sort, a condo association, a neighborhood association? Is there some association that governs these properties? If there is, they're going to have bylaws and rules that have certain requirements that you need to abide by if you have property that's located within this association. So the thing you need to do is check with the rules, and are you abiding by the rules? There are dozens of those rules that you may or may not be aware of that you need to check. And then if they are following those rules, and you don't necessarily agree with them, you've got to follow whatever the rules are to seek to change them. And
I think that here's the misconception a little bit, is that we're used to thinking that within our own domains we're the king.
Right.
And it's very much more the case nowadays that residences are located within common interest associations or communities, whether they're condos or cooperatives, townhome associations, single-family subdivisions that have associations. But whenever you go into any kind of a common interest community, you're saying, I agree to abide by whatever rules are adopted or are partly adopted within that association. So you aren't necessarily the king within your own domain there. I mean, because there are some condo associations that say, have rules to say you can't rent condo.
Right.
So, but if you're going into a common interest association, and kind of what the rules are and how they can be changed after you own the property, and they can apply to you.
Right.
Quickly here, talks about rental finding places and listings in MLS, so some of their listings and others. How can they do that? We really don't have enough information here to answer this question. You really need to look at what are your MLS rules and on putting those listings in the MLS, and on when is that required. And the other issue is sometimes owners say, no, you can't put it in the MLS, and that's usually a permitted exception from placing the property. That is a permitted exception from placing it in MLS, but you really need to look at what your local MLS rules are on that.
Right. We have some other questions that have come in, but they're going to relate to that very last question
Okay.
we got to right at you started. So I'm going to handle this one. We got this question: if you request or define the rental dollar amount as first and last month's rent, as opposed to first month's rent and security deposit, do you have any interest on the last month's rent? Well, with state statute, the Security Deposit Return Act,
Interest?
it's a separate act from the Security Deposit Return Act, but it is the Security Deposit Interest Act, and I laugh because we discussed that earlier. The Security Deposit Interest Act in the state says, if you're a lessor of residential real property that contains 25 or more units in a building or a complex, and money says who receives a security deposit from a lessee to secure the payment of rent, then last month's rent is a security deposit, and you would have to pay interest. Under state statute, if you're in a big...
The other requirements.
The other requirements. One, local ordinance, because there's out there that have fewer or size complexes to which those apply.
Right.
Last question.
The last question and there was a question came in about the association management, about managing your own properties. Remember, this is association management. If you're managing your own properties, that's one thing. If you're managing an association in which your own properties are located, the association, not the property management, that association management license, if you're receiving compensation for that from that association, and it meets the requirement, it's 25 units, maybe for 15. I'm not, don't remember all. But if association management, you may end up needing that other license if you're receiving compensation for that. Then the question that came in that relates to this: if I rent a property that I own, Realtor owned, or licensee owned, what agency disclosures should I use? Well, number one, you should give a notice of no agency to the tenant, because you don't want to be their tenant or their agent in that.
Can't be their agent.
Cannot be
License law.
Yeah, because
you've got to give disclosure that your licensee status. You have to tell them two things: that you're a licensee and that you're not their agent.
That's right.
Because you can't be a dual.
And then you need to look at what's your broker's policy with regards to rental of that unit. This will require you to do that through the brokerage company. You look at your broker policy and your agreement with the broker. Or brokers say you can go ahead and do that on your own. So that will control whether you do it yourself or whether you need to do it through your broker. And then also you need, what we're talking about too is, like say, if you're the sole owner,
right.
You've got to be, if you're the sole owner, you can be doing it on your own behalf. And if you're not the sole owner, you're doing it on behalf of others as well. Now, it needs to be through a brokerage company at that point in time, if you're not the sole owner, because you're representing third parties and compensation. So, kind of some of the questions, a whole lot more questions about if it's agent-owned, but that's...
Right, like if you set up a little corporation. Are you a sole owner? Probably not. So there are the questions.
Well,
we received.
We've hustled through these questions trying to handle them all. We've got room a few minutes late, and we hate to do that, but
started a couple minutes late.
We may have. So, but we really appreciate all of your interest in this topic. I think take a break from it next month. We've had 2 in a row here. We'll figure a different topic and let you know about that but we hope to have you back here listening, and we certainly appreciate all of your questions. If you've got follow-up questions, send them to the hotline, call or email, and we'll try to get those answers to you, whether they be related to this topic or other topics or clarifications, whatever the case may be. But get your interest and your questions, and wish you the best day, and good weekend upcoming.